Losing someone you love is already one of the hardest things anyone can go through. But what happens when all that grief gets tangled up in legal confusion, all because there's no will? Well, today we're going to break down exactly what happens when those final wishes aren't written down, and more importantly, what you can do to protect your own.
This quote just nails it, doesn't it? It really gets to the heart of the problem. Without a will, your control over your own legacy, it just vanishes. It's no longer about what you wanted. It's about what some impersonal, generic state law says. And that shift, well, that can create an unbelievably stressful and painful situation for the people you care about most.
So there's actually a legal term for dying without a will. It's called dying intestate. And when that happens, you're basically adding this huge layer of overwhelming logistics and even potential family conflict right on top of a family's grief. It turns a deeply personal process into a very public and very cold legal one. And here's the crucial part. It's not the family that gets to decide how to honor what they think their loved one wanted. Nope. Instead, these things called intestacy statutes, which are basically just a rigid one-size-fits-all rulebook, they take over completely. Every single decision is made by the book, not by the heart. Okay, so how do you avoid leaving your entire legacy up to chance like that? The answer, believe it or not, is a surprisingly straightforward legal document, one that puts all of the power right back where it belongs, in your hands. It sounds kind of fancy, right? A last will and testament. But at its core, it's just what it sounds like, your final word. It's a clear, official instruction manual from you for your family that says exactly who gets what. Honestly, this one document can prevent a world of confusion and arguments, especially when your family is at its most vulnerable. And a will does so much more than just divide up your belongings. You get to name an executor. That's the person you trust to make sure everything gets done right. And so importantly, you can name a guardian for your kids. You can even make sure your pets are taken care of. It's an incredibly powerful tool for just peace of mind. Now listen, this is absolutely critical to understand. State laws, they typically only recognize legal spouses and blood relatives. That's it. So if you want to leave something to a long-term partner you're not married to, or a lifelong friend who's like family, or a charity you really care about, a will is the only way to make that happen. Without one, the law will leave them with absolutely nothing. So we've seen how a will gives you control. But what does it really look like when you don't have one? Let's take a closer look at what actually happens when the state's intestacy laws kick in. So remember that word, intestate. The second someone passes away intestate, their family, their spouse, their kids, they lose all their legal say in how things are divided. The whole process gets handed over to a court that has to follow the strict letter of the law, no matter what anyone knows you would have wanted. I mean, just look at this. The difference could not be clearer. With a will, you decide. You can include anyone you want, friends, partners, your favorite charity. Without a will, the state decides, and the list of who's allowed to inherit becomes very, very short. It's just a stark, total loss of your personal freedom. And here's the final, kind of shocking result of that very short list. If the court can't find any legally recognized relatives, your estate doesn't go to that close friend who helped you for years, or the neighbor who was always there for you. No, everything you've worked your entire life for is just absorbed by the state, gone. It's not just about who inherits either. Dying intestate forces your estate into this long, burdensome legal process called probate. And as your family's about to find out, this process has some pretty significant hidden costs, both in time and in money. So what is probate? Well, you can basically think of it as the court's formal bureaucratic mechanism for taking over your estate. The whole thing gets frozen until a judge can officially hand things out according to those rigid state laws we talked about. And I'm not kidding when I say it's a long process. We're talking anywhere from a few months to a few years. Just let that sink in for a second. For years, while your family is trying to grieve, they could be stuck in this legal limbo, just waiting for a court to sort it all out. It just drags out the stress and keeps them from getting closure. Oh, and this long, drawn-out process, it is not free. In fact, it can get incredibly expensive. All the court filings, the administrative costs, the lawyer fees, they all get paid directly out of the estate's assets. That means the inheritance you wanted to leave for your loved ones gets chipped away, sometimes by a lot. It's money that should have gone to your family, but instead it's spent on bureaucracy. So after hearing about all the delays, the costs, and that total loss of control, the path forward becomes pretty clear, doesn't it? The best way to protect your wishes and your family is to take one simple, proactive step. And that usually means getting some professional guidance to make sure it's all done right. You see, working with an attorney who specializes in this stuff isn't just about filling out a form. They translate all the confusing legal jargon, they ask you important questions about your life that you might not even think about, and they make absolutely sure the final document is legally rock solid. But really, what they provide is the most valuable thing of all: peace of mind for you and for your family.
At the end of the day, it really all comes down to this one simple question. Who do you want to write your final chapter? You or the state? Your legacy is your story. Make sure you're the one holding the pen.